Now, you're the Minister for Workplace Relations, as I mentioned. There's this issue around the engineered stone bench tops for kitchens. It's led to some really problematic health outcomes for tradies, a number of them working in this space with silicosis. Mike Freelander, one of your colleagues, says you should just put in a ban, immediate ban on them, on the import of these things. Why not do that?
The previous government had a situation where we weren't going to even consider whether there would be a ban until June of next year, and that's when the work would be started. I took the view, and the state ministers, regardless of political colour, took the same view, which was we needed to start that work now. When you talk about a ban, there's actually some complexity in terms of where you draw the line. So engineered stone, some of it can be, up into the very high 90% of silica content there, and they're the examples where we're finding the real risks of silicosis for workers. Where you get to other percentages, so you can get engineered stone, for example, where it's only 40% silica. In those situations, you sometimes have in engineered stone a lower percentage of silica than what you get in natural stone. So we need the work to be done to work out, okay, what would a ban look like? Where would you draw that line? And how do we phase it out? No matter what we do, this will be a problem in Australia for the next 40 or 50 years. Because while whoever might have engineered stone in their kitchen or bathroom at the moment, it's installed, it's safe, it's not going to cause them a problem. The moment they come to renovate, or if there's a knockdown rebuild happening, we're going to be back in the same sort of world we've been with asbestos. So there's a whole lot of legacy issues that need to be dealt with Safe Work Australia. So everyone would always like this done yesterday. We're going to do it sensibly. We're going to work out what the proper options are, and then state ministers will meet at the latest in 6 months' time, but we're all hoping the work will be done much sooner than that to work through what we can do unanimously. You also need to bring the states with you on this. All of these laws, it's not a Commonwealth jurisdiction on its own. We've got 9 different governments, all with regulatory powers here, and we need to work together.
On a couple of other matters, I know that the Shoppies Union has brought a claim to the federal court on behalf of thousands of workers at McDonald's across 1,000 sites or thereabouts. Their claim is seeking around $250 million. This hasn't got a lot of attention, but it's a big story. Have you got any update for our viewers this morning on that claim and the government's position?
Yeah, so that case has been running, and we've been, basically, standing back, leaving it to the courts to work it through between the union and McDonald's. What's happened more recently is one of the litigation law firms, Shine Lawyers, have turned up, effectively making the same claim but through class action. Now, the claim they're making is for a lower amount. It doesn't involve interest. It doesn't cover all the same workers, but a lot of the same workers are covered. And the courts are now deciding, well, do they go with the original claim from the union, or does the litigation law firm's claim now take over? The problem's this. If the litigation law firm claim takes over, then all the costs that law firms claim and the percentages that they claim come straight off the balance of what the workers would otherwise get. And so I've taken the view, and the government's taken the view, that we need to intervene in this case. So we're now notifying the parties and the court that the government's going to turn up. It's for the court, obviously, to determine how much is owed here. But whatever is owed, I want to make sure that the workers get every cent of it and none of it gets diverted off to law firms.
So what does the government intervention mean? Does that mean that you're there on behalf of the workers? How does that work?
Now, we're there basically saying the government of Australia has an interest in this. As you know, the government's got very strong policies about wage theft and about making it a criminal offence. We've been doing everything we can to get wages moving, and we're trying to cut those loopholes that undercut wages, and people being underpaid is a critical one of those. This is right at the core of what the government's trying to deliver. To have a situation now where something in the order of 25% of an underpayment claim might not get to the workers, that's something the government has an interest in. So we'll be turning up to court and making the legal case as to why the case from the union, where the workers would get 100% of the funds, is the one that should be allowed to proceed.
One final question, another workplace matter. This is Monique Ryan and Sally Rugg, the former Chief of Staff to the Independent. Is this a test case for what is reasonable work hours in the Parliament?
Well, you've had very few cases of this nature actually. Not often they've been settled over the years. So to the extent of it being the first time I'm aware of that it's got to this sort of public point, those principles will be worked through. What I will say is everyone in the Parliament, whether they are members of Parliament, whether they're the staff, or indeed whether it's the people working in the press gallery, everyone works hard. Everyone works hard. We're all trying to deliver better balance across that. And, I'm not going to form a view. I don't know enough about the facts between the different parties here. But it's a workplace where everyone works hard and where we've got a job to do to make it a better workplace for everybody there.
Tony Burke, appreciate your time this Sunday. Thanks.
Great to talk to you, Kieran.